Morning, everybody. We are due to start our virtual employment law seminar. It's our first virtual employment law seminar for obvious reasons. We normally run these in person, but obviously current restrictions mean we can't get together in crowds. Before we get started, I just wanted to do a few introductions for you. So throughout the seminar, we will be having talks from myself, Sue Watson and Abby Ashford. And we're also supported by a team at Arden who will be answering any questions, technical questions you have throughout the session. So when we normally run these webinars and seminars, we obviously like to have a bit of audience participation. It's slightly harder to do that in a webinar scenario, but we are going to try and make the most of that. There is supposed to be 394 delegates on this webinar. So obviously when you've entered the session, you are all on mute currently, but we do want to try and encourage you to ask as many questions as you can throughout the session. Just some quick tips of how to do that. You should all be able to see a GoToWebinar chat panel. One of the options there is questions. So you can type your question in there and that will come to the panelists. And then we'll have a break after each section to field some of those questions. If there is a lot of questions, we might only answer 3 or 4 and then move on. But after the session, we will come back to everybody else whose question wasn't answered in the session. And we're also looking to create a summary of all the questions asked and provide that as part of the pack after the webinar. For those of you who are brave enough, there is also the option for you to ask your question live on air. So on that same chat panel, there's a button circled there that shows you putting your hand up. So if you wish to ask your question out loud, then that's fine. We'll see you raising your hand, and then we'll essentially allow you to speak by unmuting you for your question. Please only do that if you're not using computer speakers and you have a headset or you've dialed in, because quite often the feedback is quite loud and can interfere and put the presenters off. So please only raise your hand if you do have a headset on or you've dialed into the call. If not, please use the chat panel and we will answer those questions for you. We'll read your question out and then one of the panelists will answer for you. We are trying to make this session as interactive as possible. So not only are we going to do the questions and answers as we go along, a couple of the sections we will also be doing polls just to try and get a bit of interaction with you. And then we'll also share the results of those with you as well. So we thought we'd start with a quick poll to get you in the mood. So the first one is really just trying to understand our audience and who's on the call with us today. So first of all, it was just a very quick questions on the type of role you're currently in. Just helps us understand our audience and also give a feel for any of the questions we might be getting along the session. So I'm going to launch the poll. That should come up on your screen. I'll just leave it for a few moments whilst you answer those questions, just to make sure that the polling is working. And I can see that some of you are doing that. Okay, about 80% have voted. Okay, I'm going to close the poll. You should be able to see the results of that poll. So there's a bit of a mixture of attendees today. Most of you are within HR, but there are some business owners and line managers that are on the session as well. So that's useful. It just gives us a feel for some of the questions we might get asked and also how we'll answer those for you. So my next question is a bit tongue-in-cheek. So not only have you got your day job, just wanted to work out how many of you are actually also school teachers at the moment. Okay. So I thought there was going to be more people also schooling their children at the moment, but there's quite a few. Obviously, 70% there saying no, and 29% saying yes. Obviously, that does present some challenges on your day job as well, and I hope you're coping under the pressure. Okay, and then the one last question before we hand over to our presenters. So the last one is just to understand whether you've been on any of our seminars or webinars previously. There's quite a mix there, but quite a few of you have been to our seminars or webinars previously, but there's 49% of people who have not come to one of these sessions before, so welcome, hope you enjoy it. We will send around links to our webinar archive and our mailing list for you to come to future webinars, should you wish to, but yeah, that's nice to hear we've got quite a few new people joining us today. So at least now we know the polls work. I will be now passing you on to Abby, who's going to talk you through her section, which is to do with the current issues that we're facing in employment law.
Okay, thanks, Greg. So yeah, I'm going to be taking you through the first session here. You can see we've split the seminar into 3 main sections: current issues, and boy have we got one major one, and interesting pieces of case law to talk to you about, and then a few future knowns to finish off with as well. Okay, so we've got lots of current issues, some recently updated, and one biggie affecting us all. Can you guess which one that is on the list just coming up on your screen now? Well, don't worry, we have lots of information on coronavirus, and we will be moving on to that in about the middle of this seminar today. All of the good work plan detail will be recapped first of all, ready for next month, and then we'll confirm the new statutory rates from April, take you through the updated information on coronavirus we have, and finish this section with a simple change of bank holiday day. So our first topic that I'm going to be taking you through is parental bereavement leave. Kicking off the first change from the Good Work Plan, the Parental Bereavement Leave and Pay Act 2018 comes into force in April 2020 next month. It will give all employed parents, so not workers or those who are self-employed, but the right to 2 weeks leave if they lose a child under the age of 18 or suffer a stillbirth from 24 weeks of pregnancy. This will become a day one right, so there will be no service minimum requirement before being granted the ability to take the leave. Parents will also be able to claim pay for this period, subject to meeting eligibility criteria, similarly to other statutory family leave, being 26 weeks continuous service, ensuring the employee's normal weekly earnings are not less than the lower earnings limit in force at the time, and where notice of payment request has been given. Bereaved parents shall be entitled to a minimum of 2 weeks leave from work, and this leave must be taken before the end of a period of 56 weeks after the loss of the child. Presently, mourning the recent loss of a child does not mean that an employer is automatically obligated to permit the parent to have authorised absence from work. This may seem surprising to some, but is in line with the fact that there is no statutory right to compassionate leave. We presented a whole webinar on this subject matter quite recently, and Of course, if you request the slides or still want to, you can do that, and you can watch this webinar again at your leisure. Also, from the 6th of April 2020, there is an amendment to the Employment Rights Regulation with regards to employment particulars and paid annual leave. This will extend the reference period to calculate a week's pay for holiday pay purposes from the previous 12 weeks of work to the previous 52 weeks. This is a big change to how this has been calculated previously, as many of us are now so used to using the 12 weeks average. Hopefully none of you still administer rolled up holiday pay, but we are recommending that you review the impact of this on your organisation and prepare for the impact on your payroll. If you have any flexible contracts that include the 12-week wording, it would be worthwhile issuing a variation to contract with the change to 52 weeks. There are 3 important changes from an amendment to the Employment Rights Act which will apply from April 6th next month. Firstly, all workers employed on or after 6th of April 2020 will be entitled to a written statement of employment particulars. This extends the reach much further than just employees and will now include workers. We are regularly asked how to know whether someone is classed as a worker or not, so I'll just run through the list in case this is helpful. A person is generally classed as a worker if they have a contract or other arrangement to do work or services personally for a reward, or their reward is for money or benefit in kind, for example, the promise of a contract for future work. They only have a limited right to send someone else to do the work in their place. They have to turn up for work even if they don't want to. Their employer has to have work for them to do as long as the contract or arrangement lasts, and they aren't doing the work as part of their own limited company in an arrangement where the employer is actually a customer or client. The second highlighted point on the slide is that employees and workers will have the right to a written statement from day 1 of employment, rather than the current situation where we have 2 months to get them their contract. So that's the main biggie here, it's from day 1. There's also additional information that the written statement needs to contain, and that's those bullets there. It's the hours and days of the week the worker or employee is required to work, whether they may be varied and how, entitlements to any form of paid leave, any other benefits not covered elsewhere in the written statement, details of any probationary period, and details of training provided by the employer. So if you don't provide any training, that's not to say that you have to put in that you will, or put something that you can't then carry forward. It's just making sure that when you provide an offer, a written statement, that these employees, when they start on day 1, they already know what they can be expected to work in terms of hours and days, what they'll be paid, if there are any benefits, training and probationary period. So they're going into this period of employment with their eyes wide open, not forgetting, of course, they might have resigned from another role, and they want to make sure that they know exactly what they're signing up to. As a company at HR Solutions, we're currently updating our template contracts of employment to make these necessary amendments and to create some new master templates, so look out for those shortly. So a couple of slides on agency workers and the change here because of the Good Work Plan. So again, from 6th of April next month, this changes the agency workers regulations, and these are going to come into force in the next couple of weeks. And the effect of the changes will be to abolish the existing Swedish derogation, under which agency workers who are paid between assignments may be exempt from the 12-week qualifying period rule in respect of pay. The 12-week rule requires an agency worker to be given comparable terms to those they would have received had they had been employed directly by the hirer. And from next month then, these contracts will no longer be permissible, and all agency workers after 12 weeks will be entitled to the same rate of pay as their permanent counterparts. All agency workers will be entitled to a key information document that more clearly sets out their employment relationship and terms and conditions with their agency. Agency workers who are considered to be employees will be protected from unfair dismissal or suffering a detriment if the reasons are related to asserting rights associated with the agency worker regulations. So if you use agency workers on a regular basis, it's something to review for sure. Going to do another poll now. Handing over to Greg the Bat.
Sorry, I've just realised that poll is not in the system. So it was really going to ask you: are you ready for the Good Work Plan? Yes, no, and some of it. So unfortunately, I haven't got that poll to run for you. But it'd be interesting to know in your Q&As whether you're ready for the Good Work Plan or not. Obviously, there's been a lot going on lately to distract you from preparing for the implementation of a lot of those actions into your written statements. But it'll be useful to know your feedback. We'll circle that around after the webinar. So while Abby was presenting, we have had a couple of questions come in relation to some of the elements of the Good Work Plan. So the first question I've got for Abby, or indeed Sue, is: can the written statement of particulars be their contract or offer letter?
Okay, I'll take that one. So in terms of the different types of documents that people send out, there is confusion. And for sure, if people are sending out an offer letter before day one, and it does include all of those details that were just on the screen, then it might be that they're actually sending out an offer letter that is in part inclusive of a written statement too. So if people are sending out very extensive offer letters that include the main statement of terms and conditions, they will be receiving that before day one. What the problem is the people that send out a very brief offer letter that just gives not enough detail now, and then they're allowing people to start and not giving a statement or a contract until after day one. So it's those group of employers that are going to have to make a change to either do a very extensive offer letter that includes a written statement of one sort of bundle or package, if you like, or if it's a very brief offer letter, the statement or the contract, whichever they do, it has to be on day one. And the main difference between a statement and a contract is a contract of employment goes far beyond just the main terms that you have to have in that document. So, for example, you might have quite lengthy restrictive covenants, these post-employment restrictions and that sort of thing. They're the sort of thing that you would have in a contract that would be a much more extensive document. I hope that answers the question.
Thank you, Abby. I've got another question here. That's there's quite a few questions on obviously written statements. So one of the questions is: I have a new starter starting on the 1st of April 2020. Do I need to give them the new style contract?
Okay, so it's the 6th of April that this is implemented. So for sure, it's got to be done by then. So all of those mandatory list of terms now has to be in place from the 6th. So any new starters that you have joining you, if it was the 1st of April, actually you get away with it. It's the 6th of April we're attending to here. And don't forget, in the current climate, you might be thinking of perhaps postponing start dates if you know that actually you're going to struggle with paying people 100% of what they would be expecting. So think about postponing start dates if you have to, and potentially withdrawing or keeping candidates warm, shall we say, until after the crisis. Thank you.
Okay, so I've got quite a few questions that have come in, but one of these answers will probably hopefully group some of these together. So it's to do with the benefit element. Do we need to include discretionary benefits in the new contract?
Well, in terms of benefits, there's quite a range of things that you should be putting in them, and basically it's anything that they need to rely on for planning their living expenses. So you've got the standard stuff such as annual leave and all the statutory things. But if you are going to be providing non-discretionary benefits such as bonuses, people may have made a decision to come and join you on the basis of that. So whether it's contractual or discretionary, you need really to be putting that in so that people know what they are likely to earn at the end of each month so that they can manage their living expenses.
Okay, and then one more question on sort of contracts. Do we need to update the terms and conditions to include these for current employees?
No, this is for new employees.
Okay, and then there was another question that came through that was to do with the parental leave. So are we able to give more than 2 weeks parental bereavement leave?
Yes, this is just a statutory minimum. Don't forget, we haven't got anything on compassionate leave at the moment, so employers really are left to themselves to decide what they want to do for compassionate leave, and it really does vary from business to business. So this is just sort of setting a minimum threshold, and it's purely for parents as well. So this is not talking about siblings or anything else where they're very much affected by the loss. So I would say this is just a minimum for parental bereavement, but if you want to do anything on top of that to support your employees, then that's fantastic.
Okay, so I think there's a few other questions, but to keep the webinar moving, we'll circle back at the end of the webinar with any questions that we've not answered. But so pass you back to Abby to carry on with her section.
Thank you. Okay, what have we got next for you? IR35. Well, we only presented on this topic on the 12th of March this month, where our webinar confirmed that from 6th of April next month, changes to tax legislation regulating off-payroll working, commonly known as IR35 rules, would come into effect. The Finance Act 2017 was the basis for introducing the new IR35 rules into the private sector for large or medium-sized organisations. Under these rules, contractors working through their own companies were going to have to be taxed at source if they would have been employees if engaged directly. However, the government announced on 17th of March that the reform to the off-payroll working rules that would have applied for people will, in the large or medium-sized organisations, will be delayed actually for 1 year. So from 6th of April until 6th of April 2021. However, the government has confirmed this was not a cancellation, and the government remains committed to reintroducing this policy to ensure people working like employees but through their own limited company pay broadly the same tax as those employed directly. It's a direct quote there. So just be careful with this one. You should be aware that if you have already made and provided inside IR35 determination or banned the use of personal service companies or PSCs, both you and your client could hold liability for taxes should there be an HMRC investigation. Therefore, you may want to obtain confirmation evidence that tax and NI is being deducted by the PSC on the full rate. Interestingly, another change to help employers who are so caught up in their response to the coronavirus is that this year they do not have to submit any gender pay gap data either. So obviously that only affects people with over 250 employees, but if you do, you'll know that that has to be a requirement each April. Apparently they will not be investigating any employers who fail to report their gender pay gap, but of course they can still be published if you wish, and should of course act responsibly to ensure that there isn't a gap. Okay, so just a little update on ICE, referring to the Information and Consultation of Employees Regulations, which is often abbreviated to the ICE regulations. They were introduced in 2005 and apply to businesses with 50 or more employees. The regulations give employees the right to request that their employer sets up or changes arrangements to inform and consult them about issues in the organisation. So from next month, an amendment to the Employment Rights Regulations implements a reduction in the percentage of employees required to make a valid request or an agreement on the sharing of information and consultation within the workplace. Currently, it is at least 10% of the workforce who must put in a request, before an employer is obliged to take steps to comply with this right. This percentage will be reduced to 2%. The requirement that at least 15 employees make the request will remain. There is to be a change to national insurance contributions payable on termination payments. So here we are, another one for April 6th next month. Currently, termination payments are subject to income tax only if over £30,000, but from next month, employer national insurance contributions will also be payable on termination payments over 30k. This will impact on those of us in HR who calculate and write varying termination payments, be that a settlement agreement or redundancy documentation, for example. Okay, just have a little look back at the agenda at what we've gone through so far on the Good Work Plan. Quite a bit actually, so we'll just move on to statutory rates now, because obviously they change each April too. Let's have a little look at those. So the government has confirmed it will raise the national insurance primary threshold to 9,500 in 2020, currently at 8,632. The national living wage has also been increased by 6.2%, and you can see the new rates on your screen there. So the top one for those over 25 is going to be £8.72 from next month, all the way down to the apprentices on £4.15. Alongside the 2020 budget announced on 12th of March, the formally announced a new ambitious target for the national living wage to reach 2/3 of median earnings and be extended to workers aged 21 and over by 2024, provided economic conditions allow. Well, we'll see how that goes. But based on forecasting, this would mean the national living wage is expected to be over £10.50 in 2024. We'll see. Okay, so the statutory rates then and the increases there. We've got a rise from £94.25 to £95.85 per week for statutory sick pay, and obviously that's very relevant at the moment with so many people on statutory sick pay. And then you've got the different family leave and statutory payments, whether that's statutory maternity, statutory paternity, adoption, parental pay, all rising from £148.68 up to £151.20 per week. We believe that statutory guarantee payments will rise from £29 to £30 too. It hasn't actually been confirmed on the government website at the moment. And we don't usually discuss statutory guarantee payments for layoff and short-time working, but as you can imagine, it's been used very much more recently. They were £28 in 2018, £29 for the first 5 days from April last year. So it is expected to rise to £30 next month, but just yet to be confirmed.
Hi Abby, it's me again. So we have got a couple of questions, and you'll be pleased to know that some of them relate to IR35. So the first question is IR35 for HR or finance?
Well, it is more in the finance side of things, and certainly when we did the IR35 webinar recently, we sort of put that caveat up front that it is more of a payroll side of things. And throughout the webinar, really, which can be watched again, that it's really key to make a difference between employment status and how that impacts in the tax world, as opposed to its relevance in the employment law field, which obviously is our main remit. So I would say it is more finance and payroll, to be honest.
Yeah, I think just to sort of add to that, I think HR tends to get involved with lots of different aspects when there are people involved, because people in the organisation just assume that it's a person, therefore HR needs to deal with it, and by default some of the self-employed or contractor contracts sometimes come from HR for them to kind of manage that relationship, but the kind of IR35 issue is definitely a finance issue, but there may well be a crossover in different organisations from experience. Okay, so I think we're going to pass on to Sue now. So just bear with us a second while we transition.
Hello, everybody. So hopefully you are now seeing the right screen, which is the coronavirus. So we've been through a lot of detail already, but let's get into the topic that's perhaps of most interest and the one that is so rapidly changing. I'm just getting news flashes now. They seem to be locking down even further at the moment. So who knows what's going to happen by the end of the day. As HR professionals, you can imagine we've been inundated with calls and emails each week in March about to handle every aspect, from the initial questions about suspected cases and travelling back from other countries, and now to self-isolation, social distancing, and then school closures, layoffs, short-time working, redundancies, and the latest situation with furloughing and refraining from travelling to work unless you have to. Who'd have thought a few months back that we'd be using these terms so frequently in our employment conversations? So now we're going to present the latest information that we are aware of, and this was as at about an hour ago. So if things have changed over the last hour, apologies, we weren't quite that up to date. We were preparing for this session.
Just need to check yours. There we go, Sue. Sorry.
Yeah, it's going through. Yeah, it was sticking a bit. So we did present a webinar on the 9th of March as we launched into all the guidance that everybody needed. That was only 2.5 weeks ago, and the situation's changed so fast that actually we've rewritten this section to bring it totally up to date. So we've got a poll, Greg. So have you got any employees who are self-isolating? So it's a quick, simple one, yes or no on this one. So we just let that run for a moment. Nearly everybody's voted now. Yep.
So it's pretty significant. 81% of you are saying that you have an employee that is self-isolating. So 19%, nearly 20%, have not yet had that experience. So obviously through this session, we'll cover off what to do if you do experience somebody who is self-isolating. I'll pass you back to Sue.
Okay. So next poll we have, yes, sorry, we've got another poll. So have you been able to allow your employees to work from home? Most of them, some of them, or not at all? So perhaps if you can do a quick poll on that one. Gosh, that's also got some interesting results coming through.
Okay, so 70% most of them, and 28% some of them. So only 2% of you have not been able to have any of your employees work from home.
So quite significant changes within our own company. We managed to move to home working last week. A number of the team already had the facilities to do so, but we did have certain members who were office based, and we had to give them the equipment and the means to do so. So we're going to have a look at all the different things that we need to consider in order to make that a smooth transition. So we are expecting this topic to generate a lot of questions. If you want to ask them as we go, please do, and we'll try and run through as many as possible at the end of this section. Okay. So we're going to have a look at, this is what we're going to have a look at, which is an overview of where we are now, and then looking at reducing risk in the workplace and how we handle different scenarios. And obviously the certifying absence and sick pay issues, and all the different options if you have to look at closure on a temporary or a permanent basis. So let's move into the first section, which is just an overview of where we are now. So yesterday saw the biggest daily spike in deaths from coronavirus, and we had 89 people, taking the total to 424 deaths in the UK. There were reports of 8,077 cases in the UK as of yesterday, and that 90,436 people had been tested. The situation is changing daily. Worldwide, there are now more than 380,000 cases confirmed. So the government is seeking ways to minimise its spread. So their original plan was for a managed spread and pushing everything back into the summer, but this has somewhat been overtaken now by following some statistics modelling that Imperial College had undertaken. The concern now is that that policy could have led to more than 250,000 deaths, with hospitals being overwhelmed. So now we're into the plan of trying to suppress the spread completely and hoping to keep deaths below 20,000. And we're watching China as it begins to lift restrictions to assess the impact of that and whether in fact the virus does return. And we'll use that in all our modelling to decide the next plan of action. So employers should already have taken action to support their employees with this, and I'm sure you all have. The Health and Safety at Work Act expects you to take measures to avoid or reduce risk to employees. So if you are still in the workplace, do make sure you keep everybody updated on what actions you are indeed taking to reduce risks of exposure in the workplace. Make sure that there are clean places to wash hands with hot water and soap, and encourage everyone to do it. Frequently clean and disinfect objects and surfaces that are touched regularly. The key one now, ensure social distancing measures are practiced by all, and make sure your managers are aware of this as well. And so their daily briefing that they might have all together in the meeting room, this really must stop. And while they might all be in the same building, there's nothing to stop them using virtual technology to continue with their meetings and be able to practice the social distancing at the same time. Also, make sure your managers know how to spot the symptoms and sick pay procedures. So the symptoms, just to remind you, is a cough, a high temperature, and shortness of breath. These symptoms don't necessarily mean you have the illness, but of course, you need to take precautions and act appropriately. Also, make sure everyone's contact numbers and emergency contact details are up to date, and look at what measures you need to do to be able to get hold of everybody in an emergency outside of normal working hours, in case you have to take serious and urgent action. So part of the preparation that you may already have been looking at is determine what roles could be worked from home, and ensure that if those that can, take their tools home with them daily. So take laptops, headsets, whatever else they need to work from home. Note that both Google and Microsoft are giving away 6 months free collaboration tools to help facilitate working from home. We're using Teams, Hangouts, there's many other products available, but they are all helping us to certainly continue to collaborate from home. And reduce face-to-face meetings and replace with video conference where possible. You will find, I think, most of clients and people who have contacted me this week are already working from home, and we are now used to the unfortunate distractions that are there as well. We've had children and dogs and pets and things walking into meetings. I don't think they can go viral anymore because it's just part of the normal day-to-day. So while you do have to try and keep professional as much as you can, there are challenges that we all have to kind of understand and adapt. If you do move to home working, don't forget some of the essentials. It's still quite important to undertake a home working risk assessment. Make sure you've got a home working policy to establish the ground rules. You obviously need to be quite flexible at the moment because of the current situation, but you do need to look at some rules to make sure that people are as productive as possible. Ensure that you've got support for employees in place. You need very good communication methods. You probably need more catch-ups and team gatherings virtually, as than you did before, because working from home for some people is quite a lonely experience, and it's quite a challenge. You also need to make sure your technology can cope with it, and that you have a flexible approach to their working hours where possible. You need to make sure they've got a safe space at home to work. There is an awful lot of press coverage at the moment about mental health for those working from home, and those that are unable to look after themselves in terms of posture as they sit in a potentially non-ergonomic fashion. You know, it might be temporary, but temporary could go on for 12 weeks, and that's not going to be a good thing, and you don't want lots of claims the other side of this. So do what you can to assess their working environment and to support them with it. And also, you know, getting up and walking around and taking frequent breaks. If you're sitting in one position, make sure you do have a lunch break. And if you are flexible, make sure they know what you do expect of them. So if you do expect them to be doing some work at particular hours of the day, then make sure that's clear. But if you've got some flexibility, then make sure also they understand what that is, to take some of the pressures off them, trying to juggle homeschooling, walking animals, and all the other things that you need to do. And do what you can to boost morale. People are very anxious at the moment about what's going on. We are all concerned about the potential of the virus getting very close to home. And so anything you can do to keep employees' morale up at this time will really help you. And if you support them, they will support you in trying to keep the business going at this time. The government really are encouraging home working where you can. We've heard of an example where the police turned up at some premises and actually closed down the offices because they could not justify why they were still going into work. It does take time to organise home working for it to be effective, so please ensure you have plans in place for when eventually we will probably all have to move to home working or close businesses down temporarily. Essential that companies only continue to work on their normal premises where it cannot be done at home. But if you do that, please do a risk assessment and take every measure you can to minimise employee contact. Social distancing is absolutely paramount in this, so you do need to undertake a thorough risk assessment. I also know of a company, or in one of the essential companies to continue through this, they actually had to close down yesterday while they undertook risk assessments across the whole business, and are bringing people in a section at a time to make arrangements with them for working going forward. But they literally just closed the business while they sorted everything out. So this is serious and needs to be taken serious by everybody. So we'll move on to just looking at a couple of scenarios during this process. So if somebody does become unwell at work, then previously we had some instructions about isolating them in a room and calling NHS 111, but that's all changed now. And basically, if you suspect somebody has developed the symptoms, then you basically send them home. Do note that there are a couple more recent additions in symptoms of being fatigue and loss of taste or smell. So I think if you have any combination of those, then you should take this seriously, and they should go home. They should go home and self-isolate, and then follow the advice to remain at home. There's plenty of information available online now as to what you should and shouldn't do, and when you should contact NHS 111 or 999. They're still available if there's an emergency, or if somebody is seriously ill and you're very concerned about them, then you must use the emergency numbers. But in the meantime, they should try and avoid touching people and surfaces and objects, and try and minimise it until they are safely home. And then when they are at home, continue those precautions. So sick pay. This has been a challenge for a lot of us as well, because the government advice did keep changing for a while. But I think it's fairly static now. So we all know we're looking at certification. Sorry. Yeah, sorry, I think I clicked on too far. So the first 7 days of absence, obviously, as employee can self-certify. from day 8, most employers require you to get some kind of fit note or medical evidence that you are still unwell and unable to work. We are asked if we can to relax those rules at the moment because people are being overwhelmed, doctors are being overwhelmed by people requesting them. If it is coronavirus related, you can get an isolation note now from NHS 111 online. And if you are living with someone that has the symptoms, you can also obtain one from the NHS website. So self-certify for 7 days. Isolation is recommended for 14 days. They don't want people going to the GP unless absolutely necessary. So please don't insist on fit notes from the GP. Please try and be flexible over this and ask employees to try and get an isolation note if possible. So the next section, that's the certification. So we're then going to have a look at sick pay. So if an employee is actually ill because of coronavirus and they meet the SSP eligibility requirements, they would of course be entitled to sick pay. If you are at home to care for someone in the same household because of COVID-19 and you've been advised to do a household quarantine, you can also claim SSP. And obviously the key challenge to us is that if you actually send someone home who's presenting themselves fit for work, but you are concerned about them, then that would technically be a medical suspension. So you would have to be on full pay. So clearly employees are told to be responsible and they are told to seek medical advice. And if they are told to self-isolate by a medical expert, they will be eligible for SSP. The government have stated that employees will be paid statutory sick pay from day 1 rather than day 4. And once legislation is passed, it will apply retrospectively from the 13th of March. And employers can claim back up to 14 days statutory sick pay as a result of the coronavirus. So then we're looking at different ways of managing the business through this period of uncertainty. It could be that your supply chain is disrupted, so you can no longer continue, or maybe you've got a reduction in customers and you might have to look at either reducing your workforce or a temporary closure. The key thing the government are pushing is to try and keep the business running as much as possible, because obviously they are concerned about the economy once we've come through this. If you have a disaster recovery plan in place, then do follow that. If not, then the things you can consider are what is most critical, what equipment do you need to do it, what can be completed remotely from home, and how are you going to communicate both internally and externally with your customers, and make sure you update all stakeholders in the process. So once you know what you can continue, or if you can continue under any format, then you can start looking at how you can manage the employees who perhaps can't work from home or who you no longer have any work for at all. So one of the things you can look at is consider their accrued entitlement of annual leave and their future entitlement. You could ask employees if they wish to take this, but remember it should be for rest and relaxation, not for because of their illness. So it is one option. Legally, you can enforce holiday, but you have to give notice twice the duration of the leave. So if somebody wanted to take 1 week's leave, you'd have to give 2 weeks notice. But this is potentially not totally helpful in this situation because you've still got to pay them for that. So the other aspect is you could consider unpaid holiday. Some employees may volunteer for this. If so, do ask them for it in writing. So other options that you can look at is a temporary reduction in the amount of work employees do, or laying them off completely. If you do have the contractual right to lay off in your contract or to reduce employees' hours, then you have a few more options, or it's slightly easier for you to implement that option now. It's one of those things that clients have been reluctant to include in their contract, but we've always encouraged them to do so, citing that actually it could be beneficial to employees if your only alternative otherwise would be to make them redundant. This gives you some chance to try and turn things around and potentially be able to reinstate them. So this is unprecedented times that it's being talked about so much and by nearly every call we get. So we'll look at, first of all, if you contractually got the right to lay off or reduce hours. So you need to look whether you've got any collective or union agreement in place regarding this, and obviously follow that, because it will have specific things you need to consider and to do, and which employees are affected by that agreement. If not, then you can have an informal meeting. They don't have a right to be accompanied, but you just need to explain the situation and the action you are taking, and then confirm it in writing. If you've already moved to home working, then you could do this as a group meeting and just follow up by email with a confirmation of everything that is happening. So what do we look at? So if you are laying people off, people are entitled to a statutory guarantee payment for any day not worked or for 5 days in any 13-week period. So the maximum at the moment is £145 under that scheme. We believe the £29 is being increased to £30 from April, but none of the government sites have corroborated that. Indeed, the government site is still saying £29, but there are a number of other sites out there that have said it's going up to £30 because it tends to go up by £1 a year. So we await confirmation of that. If you usually earn less than £29 a day, you'll get your normal daily rate. And if you work part-time, your entitlement is worked out proportionally. You've also got short-time options if they're going to earn less than 50% of the pay they would normally earn. So you have got another option, if you've got the clause in your contract, to implement people working half their normal hours, and they'll just be paid for half their normal hours. There isn't a limit per se for a layoff, but an employee can claim redundancy pay after 4 continuous weeks of layoff or 6 weeks in a 13-week period. People are normally using this process to avoid redundancies or to delay the decision about a redundancy and to keep things going for a little longer. So these options need to be considered carefully, or whether or not actually indeed it is more beneficial to go straight into redundancy consultation. We are going to look at all the other options in the next few slides. So now the big one, the coronavirus job retention scheme. This scheme has been brought in by the government, particularly for those who have a layoff clause in their contract, to say that you can use this term that's been introduced. It's only really been used in America before, to classify staff as a furloughed worker and basically lay them off for a period of time. And the government have confirmed that if you do that, the employer can claim a grant of up to 80% of wages for all employment costs, up to a cap of £2,500 a month. During a period of furlough, the contract continues, so it is exactly like laying staff off. Staff remain employed. They remain on the payroll, and they are will be processed through a new HMRC portal, which is where the employer will claim the support, the grant from the government. During furloughed hours, they must not undertake any work. That's for you or for anyone else during the hours they are furloughed for. So if they work for you part-time, say it was 9 till 1 every day, during the 9 till 1 period, they cannot work for you and they cannot work for anybody else. If they had another part-time job in the afternoon that was from 2 till 5, then they can continue with those works, or they can work elsewhere during those hours. So it does need careful consideration about when you come to furlough workers. You can fund the difference, so you can pay them their normal salary and claim back 80% of that. which some employers may be able to do. It depends on you know, what funds and cash you have available to be able to continue going through this period. If your salary is reduced as a result of these changes, you can apply for support through the welfare system or through universal credit, particularly if you are on the lower earnings, close to the lower earnings level. The portal, the HMRC portal, is they're reckoning it could be the end of April before that is finally launched. They are working on it at the moment, but it is quite complex, we are led to believe. So if you have a cash flow issue, businesses are encouraged to look at and explore the coronavirus business interruption loan that the government have made available, but they are actually pushing you to look at your own banks first of all, so whether or not they can act quick enough to enable you to have the cash flow to continue going until the end of April, or whether you're already able to fund March and April salaries and then just claim back the grant when as soon as it's available. This is the big decisions that a lot of our clients are having to take. And the key thing is you should be furloughing workers in order to avoid making them redundant. So you need to be careful, particularly if you don't have a clause in the contract at the moment, that this is a mitigation scheme to avoid taking drastic action. Obviously, the government don't want to have massive unemployment figures as a result of this. They are trying to help businesses keep going and trying to help people stay in work as much as possible. If you don't have a layoff clause in the contract, then you can negotiate and agree one through a variation of contract, and you can do it fairly quickly. Some of our clients have managed it in a couple of days. And then once you've got the layoff clause in place, you can designate them as a furloughed worker, and you can then apply for the funding as soon as it's available. The government have said they will backdate furlough payments to the 1st of March. So, and it's initially for a period of 3 months, but they will review it if it needs to be longer. So if you have laid people off from the 1st of March, then you should be able to claim back 80% of the wages. We have been advising people about the emergency layoff clause and kind of tying it in and trying to get a clause in place. As long as it is a way of either delaying or avoiding redundancies, then this minimises the risk of trying to bring this in sort of urgently and as an emergency stopgap measure. But clearly, if you lay off without a clause in the contract, then potentially it's a breach of contract and you should pay them full pay. So it does need handling very carefully. So we'll just look briefly as to how you could attempt to gain agreement to a layoff if you don't already have the clause in your contract. So you can get everybody together, and virtually is probably better at the moment. Explain that you need to have an emergency plan in place should you be forced to shut down, and that they've got two options at the moment. One is to be laid off for a period of time, remaining an employee, and to return to work when this is deemed possible on statutory guarantee pay using coronavirus job retention scheme, perhaps use holiday. The second alternative is to be made redundant and cease to be an employee. And basically you say to them, if they don't want option 2 and they do not agree to layoff, the only option you have left is to pay them full pay or to make them redundant. So it kind of focuses their decision on whether they want to remain an employee or not. If they do agree to option 1, they will need to sign a variation in terms so that you don't breach the contract when you implement it. For short service employees, you may want to go down the redundancy route because they have no statutory right to redundancy pay, but do check the contracts to make sure. And you could do this fairly quickly with a short service employee. You know, day 1, announce you're making the redundancies and why, and then give them a letter explaining they're at risk and invite them into a consultation meeting on day 2. and day 2 have the meeting, take the notes, capture the notes, if that they don't want the option of layoff, and if they don't, make a decision to terminate and give notice. So you can do it fairly quickly with a short service employee. However, just a little word of warning, if you do take that route, you need to make sure you avoid discriminating, because short service employees, LIFO is not a totally safe route to go in case you're discriminating indirectly. So we're happy to advise on any risks you may have in that process. All the processes have some element of risk because current employment legislation is still in place and still protects employees, but clearly there are options to make emergency decisions as long as they're done carefully. And if you have over 2 years service, then you would need to follow the full redundancy consultation process. So we're now coming up to a poll on the coronavirus. I think I saw that one loaded, didn't I, Greg?
Yeah, I've checked the others, they're all there. So yes, we have another poll. After this poll, we will answer lots of your questions, so lots of them have come in. We're just going to give Sue a little bit of a breather so she can have a swig of water and then answer your questions. So the poll is launching now. Quite simply, as a business, have you had to do any of the following? Furlough employees, make redundancies, lay off employees, or introduce short-time working? Okay, I'm just going to share those so you can see. So just to give you a bit of reassurance, I guess, that you're not the only ones in this situation if you are having to do any of these. So obviously there's furlough employees at 42%. So a lot of you have already looked at that and have implemented it. 7% have made some redundancies already, and then 70% are laying off, or 24% with introduced short-time working.
Quite a lot of people are already furloughed employees, even though we actually don't have any detail at the moment, which is quite interesting. We are still waiting for a lot of clarification. We're trying to be advised, get your layoff in place if you haven't got it already. Warn employees, this is what you're trying to do, this is what might happen, and then bring in the introduce the furlough concept, and then bring it in as soon as you have to, but not sooner.
Yeah, so there are lots of questions, and I'll try to group some of them together so that you can answer a lot all at the same time. But I think, any that relate to furlough particularly, there isn't a lot of guidance out there. So whilst we might give you our spin or our view, we are still waiting for the further guidance to come out. So there'll always be with that caveat. But we will come back to anybody whose question we don't get to answer in this session right now. So there's quite a few around holiday. So I know you covered it in the slide, Sue, there. But is there any general guidance on annual leave? Can companies tell employees to take a certain amount of leave?
Yes, I mean, you can't force them to take it immediately. You can advise them the situation you're in, any potential, consequences if they don't, and see if they will help you out. But I mean, in the working time regulations, you do have the right to give notice to take leave. You have to give twice as much notice as the leave that you want them to take. So if you wanted them to take 2 weeks leave, you would have to give 4 weeks notice, which might not be soon enough for you. So you are really relying on goodwill, I think.
But there's also the second sort of aspect to that, isn't there? That, under the working time reg, you are supposed to take a minimum number of holidays each year. So there will come a point, if this situation drags out, that you might have to make people take holiday for their own health, even if they just sit in the garden and don't work for a week or whatever. Hopefully this isn't going to go on for too long, but current thinking is it's going to be at least 12 weeks, but we'll have to see how that goes. But it is worth thinking about whether you want to start encouraging staff to take the odd day here or there, if only to get them to do something different than to work while they're working at home. There was another question on annual leave, which was, can you basically have an employee on furlough who's furloughed? Can they book annual leave during this period to top up essentially the 20%?
It's an interesting question, and one we don't actually know the answer to yet. It's like lots of things. What happens if you're off sick while you're on furlough leave? What happens if you get pregnant while you're on furlough leave? All that kind of scenario. We're not sure. We don't know if the government will allow you to come in and out of furlough leave, a bit like if you take holidays while you're on sick, or whether they will, and whether similar to sick pay, where you can top it up to full pay if somebody takes holiday in sick leave. We don't know whether they will give us that flexibility. I know they're trying to keep it as simple as possible, but it's going to cause a lot of questions if they don't clarify soon.
And I think just on that leave point, you don't really want all your employees to be storing up all this leave, so you might want to think about getting them to take it, because you know, when this is all over, you're going to want your employees to be back in the office and sort of contributing to essentially boost the economy, in the words of Boris Johnson. So it might be something you want to think about over the next coming weeks, about getting people to use some leave. Then we've got some questions around sort of the sick pay element of it, and I think we covered some of it in the slides, but I have an employee who's classed as being high risk. Should they be self-isolating, and what are their entitlements if they do?
If they're self-isolating, they're advised to self-isolate, either because they're in the government's high risk category, or a medical practitioner has told them to, then they would be entitled to SSP from day one. Yeah.
Okay. And one of the questions is, what are the arrangements or entitlements for staff on 0-hour contracts?
Well, this is a ever-moving feast, and we're still waiting for confirmation as to how furloughing affects 0-hour contracts. But in order to minimise the risk of falling foul of the part-time workers regulations, which they do fall under, or running the risk of a potential discrimination claim, contractual benefits should be the same, prorated, as for full-time colleagues. So they do have a right to national minimum wage and to paid holiday, and statutory sick pay is available to 0-hours contract workers, as long as they've done some work for you, they follow your rules about reporting sickness, and they earn on average at least £118 a week before tax. So you'd need to work out if they've earned £118 or more or less in the 8 weeks prior, and if they have less than 8 weeks service, it will be the average since day one. So yeah, some people would be entitled to sick pay. As to their entitlements for furlough leave, etc., we're still waiting for clarification.
Thanks, Sue. So another one is about working from home risk assessment. So there's a couple of questions on that. So broadly, some people are saying, should we be doing them, and is there best practice way of making sure that they are happening?
We believe you should be doing them. I think the risk you've got is people working on laptops, hunched over, day in, day out for hours on end, sitting on the dining room chair, at the dining room table. You could end up with a claim for bad back, bad neck, all sorts of things come the other side of this if they're doing it for a long time. You do have a duty of care still, whether they're working in the home or whether they're working in your own premises. So yeah, I think it's very important they undertake a risk assessment. There are a number of things they need to look at and to consider, and if they do raise any concerns, that you should do what you can to help minimise the risk. Simple things like making sure they're working at the correct height, they have a chair available. I mean, if it's feasible, can they borrow a chair from their office? You know, is there a desk spare they can work at? Are they in a room that's well ventilated? And you know, all the conditions you have to consider in an office, you should really consider in your home environment.
Yep. So there's another couple of questions around sort of the SSP element, and then the crossover with that, if that the company is now closed essentially, so the employee can't back to work, and then what happens if they furlough. So broadly, it's around you know, if you have somebody who's self-isolating, either because they live with somebody who has got COVID-19, or they think they have it themselves, and the company is now implementing a furlough scheme. What should be the process? Should you be taking people off of SSP and putting them on furlough, or do you wait until that kind of SSP period or the sick period of the 14 days expires?
I think the ruling is that you can't furlough somebody who's off sick, so they have to return to work. It's the same if they're on maternity leave. They have to return to work for you to be able to furlough them. So if they're not already attending work, then they should, because of sickness, they should continue to receive sick pay.
And would that be the same then for people who are essentially being shielded for the 12 weeks?
I would think so, yes, because you can't furlough somebody just because they are off sick or just because they are shielding. You can only furlough because there's no work available for them and they're not available for work anyway. So I think the argument is that they should stay in the state they are at until they're ready to come back to work. When they're ready to come back to work, you can then furlough them.
Yeah. So one of the questions was quite simply, why would you do any of these things and just simply not furlough the members of staff? And I think in reality, unfortunately, some people started this process before the government introduced this furlough arrangement. So some people might already be on SSP or have been isolating. Otherwise, yes, they might have just furloughed and have the condition whilst being furloughed, and the company may or may not ever have known about it. But I think that we are where we are. If people have been identified as being sick, or are shielding, or you need to take the 14 days or 12 weeks, that's where we are until the government changes that guidance. We wouldn't be advising anybody to change that stance. Is that your view, Tim?
Yeah, I would agree, and I think I have seen one commentary by a lawyer that said that if somebody's taken sick during furlough leave, that technically they should only be paid SSP.
Oh, right.
So I don't know. I say it's one of these many things that we have hundreds of questions listed that we want to hopefully have answers to very soon. But yeah, it's a difficult one.
And so then I was kind of leaving the best for last, because obviously there's a lot of questions about, well, what is that £2,500 made up of? You know, is it including tax? Is it included NI? Should we continue paying the employees' pensions and the employers and the employees' contributions? Some people have company cars. What do we do with the company car? All those types of questions. And I think quite simply, speaking on everyone's behalf, is we don't know. The government has not given guidance as to what is the breakup of that £2,500 currently. As soon as we know, if you subscribe to our news, we will email out and give everybody that clear guidance as soon as it's out.
Yeah, I think that's true.
I think that's probably 15 questions all in one answer, but it's probably not the answer everyone wanted to hear.
Yeah, it is. I reread the government kind of wording on that last night when I was double checking the slide, and the slide is taken exactly from what the government have posted, and it does imply that they will pay wage costs up to salaries of 2,500. So we are hopeful that that's what they mean. The government have been so vague in a lot of things, we can't be totally sure.
So there's another question that relates to furloughing, which is probably a bit more of a practical question. Do we need to cut all contractors before furloughing employees?
That's a difficult one, because I think the whole process of whether you can continue, what work are they doing? Can it be done safely? Are they doing the same work as employees are doing? Because the 80% is only going to apply to employees, so it's unlikely to apply to contractors. So yes, I think you may need to terminate the contracts with contractors if they can't continue to work safely, or you no longer need them to do the work they're doing.
Yeah.
I think that should be treated separately, kind of as a separate kind of issue and process.
Yeah, I think it's kind of probably linked to how one question was, do we have to go through a process in terms of choosing who we furlough?
Yeah, I mean, it should be, because their role, there's no longer work for them to do. So it's the normal kind of redundancy criteria in terms of why would you make them redundant? It's because there's no longer any work for them to do, or you've done a restructure or whatever. Those rules are sort of going to apply, because that you should be furloughing because you no longer have any work for them to do, because they cannot work during the period of furlough leave.
But I guess there might be a downturn in work, and that's why you might furlough some employees.
But
I think it's fair to say, if you are selecting anybody, you need to be clear as to why you've selected that certain group, because you could be exposed in the future to claims of discrimination. Yeah. If, for example, if you chose all the female members of staff because they had to look after their children over the summer holidays, or not summer holidays, but with the schools being closed, they might take that decision that they've chosen the women because they think that the children would be the ones looking after the children, and that might not necessarily be the case. So there is a potential realm of discrimination claims if you are not. If you can't defend your rationale for choosing those individuals that you are furloughing. Yeah. I think in a lot of cases, people are just going to furlough a lot of staff because there is no work period, not because there's a downturn.
Yeah, it's either premises, or businesses.
Yeah, so there's quite a lot of other questions, but I think we've covered a lot of them as we've gone through the slides, and they overlap with some of the other questions that have been asked as we go. All I would say is we will come back to anybody, so we will collate all these questions into an FAQ and send them around anyway, and if anyone's still got any questions, then we're happy to sort of have a continued conversation. So I'll probably close that questions now, Sue, and then pass it back to you.
Okay, yeah, we'll do.
Or Abby?
It's Abby, yeah.
Yeah, go on, pass back to me. It's my turn to have a bit of airtime. Okay. Here we go. Just transitioning back to my screen now. So, in terms of current issues then, we went through all of those good work plan issues, statutory rates, Sue's part on coronavirus. And I'm just going to finish off now with a bit of a lighter note. We've talked about holidays. And I'm going to move us on to VE Day, because the early May bank holiday, usually held on the first Monday of May, has been moved this year to mark the 75th anniversary of VE Day on the day itself. Therefore, across the UK, the bank holiday will fall on Friday, 8th of May, instead of Monday, 4th of May. It's only the second time the early bank holiday has been moved. The only previous time was to mark VE Day's 50th anniversary in '95. For full-time staff working Monday to Friday, this change in date will not create too much disruption. However, time should be given to look into part-time employees' holiday entitlement and their working patterns, as this change in date could affect their overall annual entitlement. Part-time employees are entitled to a pro rata amount of time for bank holidays equal to a full-time employee. Therefore, for a part-time employee whose contractual working days are Monday, they will see an increase in their overall entitlement to allow for them having to work on Monday the 4th of May, whereas a part-time employee who has Friday as a contractual working day will see a decrease in overall holiday entitlement to allow for their time off on Friday the 8th of May. We're talking about this after the coronavirus slides. There's so many people by this point may indeed be furloughed or out of work, but we will press on. And one more slide here on B Day, and that's that obviously this may impact less people as we have so many workforces laid off or furloughed or about to be, but organisations who choose to honour bank holidays on the days they fall will simply need to inform the workforce on which days the bank holidays fall throughout the year and the change to the date for the early May bank holiday. It's relevant where you still have people working come May time, and to ensure that all employees plan to attend work, whether or not that's from home or not, on Monday the 4th of May. Early communication of the change in date is advised to ensure that staff can make any necessary arrangements, and it's advisable that organisations update their holiday calendars, whether this be an online booking system where dates are already input, and you may need to liaise with your system provider to ensure mass update, or spreadsheet, paper records, or wall planner, whatever you use. Okay, so that's the end of the first section, looking through current issues. Now I'm going to move us into the second section. Not a very long section, but it's one where we picked out 4 interesting pieces of case law. It is an employment law seminar, and it's important, I think, to remember that when we are out of the other side of this current pandemic, we will, thank goodness, be getting back to some form of normality. We shouldn't be lulled into thinking that we don't have to be concerned with employment rights and legislation, that managers can do whatever is necessary to see us through hard times. Whilst emergency legislation is being brought in, we still have to adhere to employment law that's in place, such as discrimination, unfair dismissal, data protection, all this sort of thing. So I've selected a few recent cases and a couple that will be giving judgments this year, just to update you on and to take away some key learning points. The first one then. Pemberton versus HMRC. We'll start off at the lower end of the pay awards, but with an employer who seems to be having to respond to a number of tribunal claims. HMRC had a customer services advisor who suffered with rheumatoid arthritis and was on the receiving end of a throwaway comment from her line manager that her condition resulted in her becoming lively when there was a flare-up. This comment was the final straw for Miss Pemberton, which is actually a real shame because HMRC had put in place reasonable adjustments, as we know we have to, such as taking extra breaks and what was called a workplace adjustment passport to help with her fatigue, pain and difficulty with executing some of her duties. Miss Pemberton won her case of discrimination and harassment, but because the ET concluded that the comment was not malicious or ill-intentioned, the award was relatively low at $4,000. I've already said that this must have been a disappointing situation for HMRC when they had put in place measures of support, but the other 3 key takeaways for me with this case are as so. Well, firstly, it's interesting, isn't it, how speaking before thinking can get a line manager into hot water. And where there are these potential risky managers working on behalf of your organisation, and some of these people are known to us, it's a real importance for diversity training. And, in these times of difficulty, training budget, often the first one to go, I fully appreciate that. But even maybe when we come out the other side of this coronavirus, it's one of those things where you do need to constantly sort of check in on what sort of training is required to make sure the staff and management in particular are good ambassadors of your company. So that's my first takeaway from that. But also, secondly, how a tribunal will look at a case to conclude whether an act has been vicious or ill-intended. And we're often asked at HR Solutions when we're advising clients to help make that call of whether something is gross misconduct or not. And this is one of the ways of helping you make a decision in these sorts of cases, be they harassment, maybe sexual harassment or something else, where you need to decide on the balance of probability. Was the action malicious? Was it willful? Did they intend to cause harm or offence? So it's quite interesting, I think, to see how employment tribunals and judges take that decision. And finally, my key takeaway is that Ms Pemberton found out about this word lively that she took offence to from the subject access request, where her manager's comments to a reasonable adjustments support team member had been logged, showing how details of a subject access request can provide fodder for a claim. So lots to learn from that one, I would say. My second one then. This was Ray versus Wellhead Electrical Supplies Limited. This is a case from Scotland published last month, which was interesting because it was the MD of the actual company he founded that put in a claim for unfair dismissal. He'd resigned in the heat of the moment at a meeting where he wanted to give employee pay rises and his fellow directors had not wanted to, and his resignation had been immediately accepted. He tried to talk to the directors the next day to retract his resignation, but this was denied. The judge concluded that someone of his seniority would have submitted his resignation in writing, surely, after much contemplation, and therefore should have allocated a cooling off period in this case. So for me, the learning here is that resignations made in the heat of the moment verbally should really be met with a cooling off period overnight. And if no contact is made the next day, the employee should be asked to confirm in writing by letter or email. Without doing this, no procedure has been followed, you see, which risks the situation being considered a dismissal. At a time of social unrest at the moment where people are walking out of work feeling it's unsafe to continue, and I've had calls such as these over the last couple of days, what do I do? My employee's walked out in tears, she doesn't feel it's safe to be at work. Well, any resignations of this ilk made in the heat of the moment should be met calmly, where possible, and if dialogue won't resolve it, allow a cooling off period overnight. My third case is one against Morrison's. I've selected this next case, despite there not being a decision delivered on this one yet, because it is the first group data breach action to be presented in court. This case involved an employee who published personal data of just under 100,000 Morrison's employees online. Initially at the High Court, Morrison's data protection processes for protecting personal data was deemed not to be at fault by the employer directly, but that they were vicariously liable for the actions of this one rogue employee. Morrison's appealed and the case was brought before the Court of Appeal and they upheld the decision. This case was heard by the Supreme Court in November and we are expecting their decision with interest. And finally, it would be remiss of me to do an employment law case law update without mentioning Uber. This is another case that hasn't been ruled on yet at the highest level and which will be fascinating to hear the result of. We await the decision for Aslam and others versus Uber this summer when we find out the Supreme Court's judgment on whether Uber drivers are workers and not self-employed. At a time now where employment status is critical for being able to claim support from the government, it has never been more important to know whether your job is deemed one of a worker or self-employed status. If they are deemed workers, they will have protection under the Working Time Regulations, the National Minimum Wage, the Public Disclosure Act, so that's whistleblowing, and the Employment Rights Act that gives the right to be accompanied at a disciplinary or grievance hearing. They'll also have protection against unlawful discrimination and the rights to be provided with a safe place and safe system of work. So, do we have any questions coming in now, Greg?
There's still a lot about furloughing and contracts coming in. So I think to kind of keep it in the same topic area, we'll try and circle back to anything that we've not already covered at the end and keep the questions to the sections for now. but there wasn't any on your case law topics. So we can pass over to Sue.
Okay, thank you.
You there, Sue? Sue, are you on mute? This is the challenge of running a webinar in different locations. I can see that she's clicking the slides, but I can't hear her. Sue, can you hear us?
Hi Sue, can you hear us? We can't hear you.
Would you like me to do some of the slides, Greg?
Yeah, I was just going to volunteer, but if you want to do that, then that's fine.
Oh, no. You carry on, you're fine.
Well, I
You
feel
overload me.
underprepared now. I haven't prepared for all of these ones. So back to me. There we go. Okay, so in this section, basically we're trying to talk about the future knowns. Obviously that you've got a lot on your plate at the moment with obviously the coronavirus, but also there's the good work plan, but there are some other stuff coming later in the year as well. So basically the Queen has a lot on her to-do list currently. She's been busy, and in the Queen's speech there was about 40 new laws announced that are due to be brought in over the coming months. Perhaps one of the most significant is a new employment bill, some of the key aspects of which include the right for workers to request a more stable contract, extended redundancy protections to prevent pregnancy and maternity discrimination, extended leave for neonatal care, 1 week's additional leave for unpaid carers, the creation of a new single enforcement body to protect workers' rights, the right for workers to keep their tips in full, and flexible working by default unless employers have a good reason not to allow this. Obviously, that's subject to consultation. So, we're probably going to get through coronavirus and have the good work plan out of the way, and then we're still going to have, as HR professionals, quite a lot on our plate still to do, unfortunately, but we'll get there as we go through it. So there's a new immigration and social security coordination, which is part of the EU withdrawal bill, which is proposed to bring in an end to the free movement in UK law and adopt a new points-based system from 2021. Under this proposed new law, EU citizens arriving from 2021 will therefore be subject to the same UK immigration controls as a non-EU citizen. The aim is to also protect the immigration status of Irish citizens after Brexit. So some of the other bills that are due to come through, some of which the coronavirus bill is currently at committee stage in the House of Lords as we speak today. So we might have a bit more guidance on that when we come off this seminar. But basically the bill will aim to enact, enables action in 5 key areas. Which SSP changes will have respective effect to the 13th of March. It should increase the available health and social care workforce, for example, by removing barriers to allow recently retired NHS staff and social workers to return to work. And in Scotland, in addition to the retired people, allowing those who are on a career break or our social worker students to become temporary social workers. It should also aim to ease the burden of frontline staff by reducing the number of administrative tasks they have to perform, enabling local authorities to prioritise care for people with the most pressing needs, allowing key workers to perform more tasks remotely and with less paperwork, and taking the power to suspend individual port operations. Containing and slowing the virus is obviously of paramount. They aim to do this by reducing unnecessary social contacts, for example, through powers over events and gatherings, and strengthening the quarantine powers of police and immigration officers. Obviously, they've been talking about that in the press, but actually this bill is what will bring that through into legislation. There's also part of the bill managing the deceased with respect and dignity by enabling the death management system to deal with increased demand for its services, and support people by allowing them to claim statutory sick pay from day one, and by supporting the food industry to maintain supplies. Essentially, most of that is already happening, so it's almost as if the bill has come through, but this bill is essentially putting it into legislation. So I don't think Sue's back yet, so I will continue. So obviously, at the start of the year, we were due to be, or we're planning to have Brexit. So when we sort of started the year, we were planning for leaving, and therefore we needed to think about data protection and GDPR, and the impact that Brexit may have on that. It feels like a distant memory talking about Brexit. Now all we talk about is coronavirus, but we still need to be mindful that the impact that Brexit has in relation to data protection and GDPR. Because if we leave the EU without a deal, most of the data protection rules affecting small to medium-sized businesses and organisations will still stay the same. And the UK has already committed to maintaining the high standards of the GDPR, and the government plans to incorporate it into new UK law after Brexit. So it doesn't feel like it's going to go away. The timing of it may just be what's up for grabs. So if you are a UK business or organisation that already complies with the GDPR and has no contacts or customers in the EEA, you do not need to do much to prepare for data protection compliance after Brexit. If you are a UK business or organisation that receives personal data from contacts in the EEA, you need to take extra steps to ensure that the data can continue to flow after Brexit. And if you are a UK business or organisation with an office branch or other established presence in the EEA, or if you have customers in the EEA, you will need to comply with both UK and EU data protection regulations after Brexit. And you may also need to designate a representative in the EEA. We haven't got many slides on it because we didn't think it was going to be a main topic for a lot of people, but we thought we'd just make sure you've got that on your radar for once we have dealt with the coronavirus. The other kind of key aspect that is still ongoing is the EU settlement scheme, which obviously relates to Brexit. So it's really just a reminder that EU citizens and family members who want to stay in the UK beyond the 31st of December will need to apply to the EU settlement scheme. This allows the individual and their family members to continue to live, work and study here in the UK. It means they continue to be eligible for public services funds and citizenships if they want to apply and meet the requirements. Settled status is not the same as citizenship, For example, holders of this status do not have a UK passport, but those with settled status and at least 6 years residence may apply for citizenship. There is no legal obligation for employers to communicate the EU settlement scheme. However, you may wish to signpost employees to the information that the government is providing. Employers are not expected to interpret information provided by the government, and indeed employers should be careful not to provide immigration advice unless qualified to do so. However, there is also an employer toolkit on the gov.uk website, which includes a briefing pack, leaflets and fact sheets, which we've put at the bottom of that slide. Hopefully a lot of you have already been talking about the EU settlement scheme with your employees. A lot of it was talked about at the end of last year, before Brexit was confirmed, and then obviously before the coronavirus. But if it is still an issue for you, it is probably worth doing a bit more research and getting that information from the gov.uk website. So this is where Sue was going to pass back to me, and we're going to look at any questions that have come in throughout that session. So just bear me a second. So it looks to me like most of those questions are still coming in about furlough and what that means. So we will, I'll just have a quick look to see if there's any others that we haven't already covered. So some of the questions about if somebody is furloughed, can they volunteer for another organisation, or can they even go and find another role whilst they're furloughed? I don't know if you want to help with that question, Abby?
Well, I mean, we do know, don't we, that you're not supposed to work for somebody else during the hours that you're contracted to the primary employer that is going to be putting in your salary and data into this new HMRC tool. So I think, although it's a vague answer, I would say not able to during those hours, but during other hours, then certainly you can work elsewhere and do the HMRC tool and get the 80% for that. But the added bit of that question is about volunteering, because we've seen on the news in the last 24 hours, haven't we, about the government and the health secretary saying who's available to come and do some volunteering to help the NHS, to help with these new community hubs delivering food. So I genuinely don't know the answer to that, because volunteering is not paid work. So I wouldn't want to give a view because I don't know the answer to that piece. That's the new piece that's come in the last 24 hours.
Yeah, I think I'd agree with that. I think you also need to be mindful that they shouldn't be putting themselves into harm's way as well. So you just need to think about what that volunteering would do, and I'd certainly expect them to talk to you about it before they did it. But yeah, we'll wait and see on some of that for a bit more guidance. But if you are on our mailing list, then we will be giving updates. If you're not, then there will be an email after this event with a link on how to sign up, if should you wish to do so.
Interesting. Just whilst we've been on this seminar, Greg, I don't know if everybody else is the same, but we'll get text now to say stay at home from the government, which is quite an interesting news. So getting that text at the same time as being asked to volunteer.
Yeah, I think they actually sent it out. Some of them got sent out yesterday, so I don't think it's a new thing, but I read it and was like, oh, what's changed? But one last question, which was on pregnant people, what to do with them and coronavirus. I'm a food manufacturer, still open, but they can't be here. What do we pay them?
Yeah, so with pregnant people, they're in the high risk. There were 4 categories, weren't there, for high risk that should be social distancing for 12 weeks. That was over 70, pregnant, a weakened immune system, or an already pre-existing condition. So that it's those people that should be socially distancing, should be at home, and that's for 12 weeks on SSP from day one. Of course, you're going to have the difficulty with some people that won't want to do that because they don't want to be on SSP. Obviously, when people go on and start their maternity leave, the way that SMP is worked out is looking back to see what you've earned, and if you've been on SSP, you're going to be on a lower wage potentially. So it's a very difficult situation where employers might need to make the call of saying to somebody, you need to make this decision, because of course, again, we're not recommending that many employers force people to go home, because that's then on full pay, isn't it? But they need to coach, I'm going to say is the word, to that employee to say, look, this is your decision, it's your baby, and it's your life in your hands ultimately. Should you be at work, you've been identified as being in this high risk category, and the government advice is to go home.
Yeah. So there's one other question that's, well, not question, someone has told us that it might be useful for you to know that the gov.uk have just announced that they have a chatbot to answer any questions from the public. I bet they don't have one to answer furlough questions though. So we will have to wait and see what the future guidance brings, but I think we'll leave those questions for now, just because I'm conscious of time. We will come back to you on anybody who haven't managed to answer the questions for you, but we'll probably pull those all together in a kind of Q&A that everybody raised, and we'll share the wider document rather than just your specific questions. It will be anonymised. We're not going to put people's names on there, but just be sharing some of the sort of questions that were raised and the answers that we're going to put forward. On the screen, you should be able to see that that's our telephone number, which is 0844 324 5840. And we also have an inquirers inbox if you want to reach out to us in the meantime. Just kind of following on, we obviously then tried to make it a bit more interactive today. It's the first time we've done one as long. Normally our webinars are about 30 to 45 minutes long. We're used to presenting seminars in front of an audience when you can gauge interest and also ask those questions as they go on. So we've tried to make it as interactive as possible, but we will be sending a feedback survey out after this session, just to give us a few pointers, because unfortunately I feel we're probably going to be doing a few more of these over the next couple of months, and obviously any feedback you give us will help us make them better. So yes, that'll be appreciated. So we do run monthly webinars. So we do have another one on the Good Work Plan, solely on the Good Work Plan, which is on April the 9th. And if you see the link on the website, that's where all our new webinars are put. But if you are on our mailing list, you will get a separate invite to those anyway. Equally, here's just the link for our newsletter, which if you just Googled HR Solutions, our website should come up, and then you can just sign up to our news there, but there will be a link on the email you'll get from us anyway. Obviously, there's a lot going on in the world of HR at the moment, but we do have a HR risk and compliance audit tool, which is free if you wish to spend some time, about 15 minutes each. It kind of goes through all aspects of HR, and we'll give you a risk report on the back of it, but equally there's one specifically for GDPR and one for Brexit as well. We haven't created one for coronavirus yet. Hopefully it will go as quickly as it came and we won't have to worry about it again. Just some other pointers there. So every one of our webinars is recorded, and we do have a webinar archive on our web page as well. So we'll send you that link after this event. You're obviously welcome to view those at your leisure. So some of you on the call are already subscribers of our HR knowledge base, some of you are not, so we've got quite a lot of new people who've joined our call today. Just to let you know that obviously we do have a HR knowledge base where there is access to hundreds of easy to use HR templates. So everything in relation to Good Work Plan is on there. There is a lot of information about the coronavirus, and it is updated daily as the guidance changes. And soon as clear guidance on furlough is out, that will be updated onto that site as well. But yeah, if you sign up to our news, you'll get our weekly email updates as well, which will keep you informed of everything that's changing in the world of HR. And that is it. So thank you for attending. It's one of our longest online events we've ever done. And also we had the most delegates, so record breaking on 2 fronts. If you do want to connect with us, we are on LinkedIn, Twitter, Facebook, and we've even got our YouTube channel where you will find all of our video archives as well, or you can access them from the main website as well. We will come back to you with all your questions, but if there's anything that that's not on there that you wanted to ask, then you can email back and we will try and resolve those questions for you. We're going to find out what happened to Sue, and we are going to close the webinar now. So thank you for attending, and we'll see you all soon.
Thank you. Bye.